In this video, we're going to discuss how to become a resident of the United States after you've been married to a U.S. citizen. This video pertains to people who have come to the country legally with a visa or some other form of legal entry into the United States and have later become married to a U.S. citizen. Maybe they got married to a legal permanent resident, but then that legal permanent resident later became a citizen. But this video is about the process that somebody needs to follow to become a resident of the United States after legally entering the country and marrying a U.S. citizen. So to qualify, kind of like what I said before, enter the United States legally, be married to a U.S. citizen, not have a disqualifying criminal history. That's an important part because sometimes that criminal history will close the doors to being able to adjust your status and become a resident. And then lastly, not have disqualifying immigration history. That could consist of many entries and exits, having come into the United States and overstayed a visa and later leaving the country, maybe a process of deportation, something like that, right? So if the person meets these qualifications in general, they may qualify to become a resident of the United States after they're married a U.S. citizen, but it's important always to talk to an attorney in person. Some of the forms that we use for this application or for this process include the following forms. The first one is an I-130, and we also include an I-130A for the U.S. citizen spouse. Later, the I-485, which is the application we send to request for the actual green card or the residency. And I-765 is usually sent so that we can request a work authorization and a social security number for the person to use while they're waiting for the green card to be approved. The I-864 is the sponsor application. It's the application that the U.S. citizen spouse will send showing their situation, their financial situation, to be able to petition and request for their U.S. citizen spouse. If they don't meet the qualifications, by the way, they can also have a co-sponsor that would also send a similar application. And then lastly, we'll send an application called an I-693, which is the doctor's sort of notes and form that they fill out after a physical examination that they send to immigration. Processing times with this take quite a long time. It depends on the city and state and the USCIS office where the applications are sent. So what people usually do is they go to uscis.gov, and we'll have a link in the description below, and they will go to the processing times, and they'll see kind of an estimate for the city where they sent their application for the amount of time it might take to be approved. Filing fees are also important with this. Filing fees in total, which immigration charges for their applications, come out around to be somewhere around the ballpark of $1,800. There's a specific amount now that we send, but immigration has announced that they're going to change those. So it's important that if you watch this video, that you look up the forms and find the specific filing fees for their forms. And one pro tip on this is that it's important to send each of the fees separate in separate money orders to USCIS. If you try to lump them all together, sometimes they can return that application. They like it so that you send the individual application fee separately, so they're not all in one big group, but they're all divided up among the applications. The process then, you send the application, and it could take a year and a half to 2 years, depending, till you ultimately get that green card. So what happens is after you send that first batch of applications, you get some notifications from immigration saying that they've received your applications and they're in process, and you get a receipt number and oftentimes what's called an A number or an alien number that you'll use for your case. And then as you wait, different things happen. You might get notices to go and give fingerprints and place fingerprints with USCIS so they can check the background history. Later, 2 to 5 months later, you might get that work authorization in the mail so that you can work in the United States and have a social security number while you're waiting for the USCIS process to go through. Then you wait for quite a bit of time, and eventually, usually with these types of cases, when it's a marriage-based case, they're going to want to have an interview at a USCIS office with an officer working at that office to determine whether the marriage is a valid marriage. The big question for the officer is whether, when the marriage took place, if it was a valid marriage, if the intent of the parties was to form a family and live together and was really based on love, and it wasn't based on an interest in obtaining a green card, right? So they're trying to determine that thing, that part. Is this marriage a valid marriage, and does it continue to be a valid marriage, or is there evidence that maybe it was a marriage that was falsified? Some of the pitfalls that we run across in some of these interviews. First of all, if the person has multiple entries and exits at the border or through the airport, oftentimes the immigration officials will want to see exactly sort of a timeline of those entries and exits and make sure that the person didn't ever overstay their visa and then leave, or didn't ever come into the United States without a visa. So they'll check through those things. If there was an overstay, then they're going to have to really determine how long that overstay was and if it still affects the case. Oftentimes, it might not affect the case if the person overstayed and then later married a U.S. citizen, because there's a group of people known as immediate relatives of U.S. citizens, which consists of spouses, parents, or children under 21. And those groups of people might have a little bit more flexibility even if they did overstay a visa. If the person has entered into multiple marriages, and so there's multiple marriages and divorces, it's important to have all that paperwork in order, because if the immigration officer sees that it was a previous marriage but doesn't see a divorce decree and now there's another marriage, they might think that this marriage is not a valid marriage yet because the divorce hasn't been finalized in the former marriage. So it's important to have all those pieces of paperwork in process and handy at the interview. Criminal charges and criminal history, like we mentioned before, might have an effect on this process. And so when the person goes into the interview, oftentimes they'll sit down with the officer, they'll start looking for through the applications, ask the intending immigrant how they came to the United States, ask the couple how they met each other, and then maybe a bunch of questions about whether the marriage is valid, and see if they're still living together, and see, based on the documents that were filed, if there's evidence that it's actually a valid marriage. What I like to tell people is to send everything you can to demonstrate that you're combining your lives, and not just a marriage certificate. Anybody can falsify one of those, but everything else. Maybe a bank account showing that both parties are using a bank account, not just one where you open it in both names and put some money in there, but both of them have been using it for a certain amount of time. Health insurance, car insurance, taxes, all those kinds of documents that will show both names on there to show that the lives are being intermingled together, and that will help the immigration officer determine that it is a valid marriage and that it's a proper marriage, and then they might be able to move forward with approving the case. In extreme circumstances, they might separate a couple and ask them questions in different rooms, and in very, very extreme circumstances, they might even do like a home visit and go and check out the home and see if they're actually living together, right? That doesn't often happen, and it probably won't happen if you file your application properly with the proper paperwork, so that there's no red flags and suspicions that arise in the officer's mind. They can see it's a pretty clear-cut case. Everything's laid out for them, so then they can avoid some of those more extreme measures of trying to determine whether the marriage is a proper marriage for purposes of obtaining a green card. We'll have links in the description below with more information about the applications, about the process, about USCIS, also information about how to get a hold of us and work with us. We've been doing this for many, many years. We've seen all kinds of things, from great differences in age of a husband and a wife, and what immigration does with those types of cases, or the types of cases where the husband and wife are living in different places but they're definitely married, or situations where there's lots of divorces and different things happening, and all kinds of other situations. And so if you have a different situation and you're interested in working with an attorney, we're here to help. We always say that we love to work with our clients so that we can give them the best probability possible at obtaining their green card after a marriage to a U.S. citizen.